Welcome, everyone. It's my pleasure to welcome you to our webinar, Reopening and Older Workers, the Intersection of the ADA and the ADEA, Legal and Practical Considerations. As DH said, my name is Esther Bigler, and I direct the Labor and Employment Law program at the ILR School at Cornell. This is a CLE program. Sometime during the program, I will be announcing the CLE code. Please put that code into the evaluation form when you fill out the evaluation at the end of the program. Please fill out an evaluation even if you do not want CLEs. I take very seriously your evaluations, and you will be able to find the URLs for that in the chat box as just indicated. Again, as a reminder, there is a Q&A box. If you have questions, please put your questions in the Q&A box. After the presentations by our panelists, I will be asking a few questions, and then I will be turning it back to the questions that you've put into the Q&A box. That will be at approximately 2:40 or so. Then I would like to go forward with our program. Older workers age 55 and above represent nearly a quarter of the United States employed population in 2019. The baby boom generation is aging, and pensions are disappearing. More people have to work to survive. The CDC tells us that people at the age of 65 or above and those with certain pre-existing conditions are at a higher risk for serious illness from COVID. That, however, does not tell the whole story as we look at the intersection of the ADA and the ADEA. This program is taking place at a pivotal time in American history. There are protests in the streets of our cities, sparked by the killing of George Floyd, and now exposing the racial inequalities in our society and in our institutions. We are in a time of change and reflection. It is clear to everyone that African Americans and people of color have been hardest hit by the COVID pandemic. There are many reasons for this, and it goes beyond the confines of this webinar today. However, as we discuss the law today, let's not forget that essential workers who are taking care of us, as many of us work from home, are overwhelmingly people of color. They are our bus drivers, our delivery people. They're operating the subways. They're working in our nursing homes and in our hospitals. They're working in the food factories, for example. Many are older. Many have pre-existing conditions. They do not have the luxury of telecommuting. They must go to work. So let's keep them in mind today as we talk about these two very important laws. It is now my pleasure to introduce our speakers. Hy Feldblum is a partner in Morgan, Lewis & Bockius. She helps companies and organizations create safe, respectful, diverse, and inclusive workplaces. She served as commissioner of the EEOC from 2010 to 2019. As director of the Workplace Culture Consulting at Morgan Lewis, she helps employers implement preventive strategies to eliminate harassment and enhance workplace productivity. Her policymaking background and the insight she has gained from enforcement at the EEOC informs her counseling of employers on compliance of anti-discrimination laws and investigation of complaints of discrimination. Hi, I want to welcome you back to Cornell. You've been a speaker for us many, many times. Lori McCann is a senior attorney with the AARP Foundation litigation. Her principal responsibilities include litigation and amicus curiae participation for the AARP on a broad range of age discrimination and other employment discrimination issues. She has prepared amicus cases for the United States Supreme Court, federal and state courts. Her publications include Age Discrimination in Employment in the New Politics of Old Age Policy and the ADEA and the 11th Amendment. She is a noted speaker on the issue of the aging workforce. What I'd like to do now is to ask Lori to begin our discussion. to give us an overview of the ADEA and the scope of the issues facing older workers. Lori?
Thank you, Esther. The Age Discrimination in Employment Act was enacted in 1967, just over 50 years ago. It protects employees and applicants for employment age 40 and over, and it applies to employers with 20 or more employees. It covers every aspect of the employment relationship between hirings and firings and everything in between. But I also need to recognize that virtually every state also has its own state law that prohibits age discrimination in employment. And many of these state laws, their protections go beyond the ADEA, and that is exactly what Congress wanted. Congress intended the ADEA to be a floor of protection for older workers and not a ceiling. In this time of COVID-19, many factors are combining to make this pandemic particularly precarious for older workers. First, as Esther has already mentioned in her opening, the CDC has made it clear that age is a significant risk factor for serious health consequences once there is exposure to COVID-19. Also, the reopening plans of many states, and as well as the White House guidelines on reopening, all state that vulnerable populations, including older people, should stay home. They're being encouraged to stay home as long as possible. Next, many of the industries that have remained open have significant numbers of older workers in them. And Esther has already mentioned a number of these, and then the intersectional factor of race. So transit workers and home health care and nursing home employees, grocery store employees, to name just a few. And then a large share of older workers are in jobs that simply cannot be done from home. So they are facing losing their jobs or risking their health or the health of their families when they return to work. And then the fallout in the economy as a result of the pandemic has its own consequences for older workers. Older workers have always been vulnerable when employers implement layoffs. And this is because of the assumptions about them being more costly in terms of salaries and benefits, and also stereotypes that they are less productive and they're less able to adapt to change. And I believe that fears of costly insurance claims from COVID-related illness and potential legal liability if older workers become sick will exacerbate older workers' risk to layoffs in this time of COVID-19. And we are already seeing evidence of this. The unemployment rate for individuals aged 55 and over jumped from 3.3% before the pandemic to 13.6% in April. And an AARP survey showed that already 30% of older workers have had a reduction in income because of a job closure or job loss. So I applaud Cornell for putting together this program because it is certainly very important and timely.
Hi. In the context,
Sorry.
in the context,
I'm so excited. I can't wait for your question.
In the context of COVID-19, please start our discussion of the ADA protections that workers have and the issue of reasonable accommodation under the Act.
Great. Thank you, and hello to everybody. And as you will see, a lot of this program is going to be back and forth questions after this very short sort of introduction setting the stage of the law. So, as I'm sure you all know, the Americans with Disabilities Act covers employers with 15 or more employees. I want to reiterate what Lori said. Almost every state also has a state disability anti-discrimination law, and it's very important to be conscious of those as you're deciding what your legal obligations are. In terms of the ADA, I think we do want to also note that the people we'd be talking about include, first of all, people who have COVID-19, who are infected with COVID-19, And the EEOC has been actually very good in putting out guidance. As someone who was a commissioner for 9 years, I know how hard it is sometimes to get things out. So I'm very pleased that my former agency is doing that. But they have essentially said someone who has COVID-19 poses a direct threat in the workplace, and that person can be excluded from the workplace. There isn't any reasonable accommodation that can be done. I will let you know that a few days ago, the Consortium of Citizens with Disabilities sent a letter to the EEOC asking for some modifications in the guidance. Some of it was really cleaning up language, but others were more substantive, and part of it was on this issue of folks who have COVID-19. But I think that's pretty clear. Those folks can be excluded from the workplace, and in fact, they need to quarantine and or get health care. A second area in terms of ADA and reasonable accommodation will be those individuals who have some underlying health condition that makes it difficult or impossible for them to wear a face mask. This could be a physical disability, it could be a mental disability. Here, as you may know, the ADA requires that employers provide a reasonable accommodation to an employee in order to allow that employee to do the job, unless providing that accommodation would impose an undue hardship. So here, and again, EEOC has provided this guidance. Employers do need to engage in an interactive conversation with someone who has an underlying health condition that makes it difficult or impossible to wear a face covering. Because maybe there is something that can be done, that that person actually can be in a location where they don't need to wear a face covering. However, for most positions, face coverings are going to be required in the workplace. Either they're going to be required because there's a state or local order requiring that in the workplace, and there are a number of those, they will, I'm sure, continue to come out, or because employers decide that they will voluntarily require employees to wear face coverings. And they're doing that in order to comply with OSHA, Occupational Safety and Health Act, has what's called a general duty clause. It's a general duty to have a safe workplace. Sometimes OSHA does actual standards. So if you violate that standard, by definition, you have violated OSHA. OSHA has not put out any specific standards about COVID-19. They haven't said if you don't require your employees to wear face masks, you have violated OSHA. But that general duty clause will be shaped by what CDC recommends, the Centers for Disease Control and Prevention. And they are recommending that anyone who's going to be in an enclosed setting, like an office building or in places where you can't have social distancing, that they wear the face coverings. So that's going to affect people with disabilities who cannot wear the face covering. And then, unfortunately, and then it is considered to be an undue hardship for the employer to allow that person to stay, because again, it might be putting other people at risk. It's sort of a direct threat to others. And then finally, a place where reasonable accommodation under the ADA will come in will be in the context of people who are asking to telework. And there, with some individuals that will work, with others it won't. And I know now we're going to get into some of those specific questions.
Thank you, Kai. So, Lori, I'd like to turn back to you first to ask you, an employer looks at its workforce and decides that anyone over 65 can telecommute, but younger employees, they have to come to the office. Does this violate the ADEA? And what about state and human rights laws? How does that intersect with the ADEA, which you mentioned those laws earlier?
Right. That's a great question, Esther. And those facts, under those facts, this would not be a violation of the ADEA. So an employer can allow its older workers to telecommute and require its younger workers to return to the office. And that's because of a 2003 Supreme Court decision called General Dynamics versus Klein, in which the Supreme Court ruled that the ADA does not prohibit an employer from favoring older employees over younger employees, even if those younger employees are also in the ADEA's protected class. So, and that's what the facts of your example are. So you could have people 65 and over being allowed to telecommute, but people 40 to 64 have to come to the office. Those people 40 to 64 would not have an ADEA claim for the more favorable treatment of the people 65 and over. So in addition to your telecommuting example, the employer could also provide, for example, extra PPE equipment to workers age 65 and over. Or they could say that older workers can get an office with a door, but younger workers would not get the office with a door. Now, then you ask about state and local laws. And as I said, state and local laws often provide greater protections. But there are numerous state laws that, including New York, I believe, that define age as 18 or over, or maybe they don't define age. So they do it totally different than the ADA. They don't define it as 40 and over. They just say age should be it be because of where age is 18 and over, then an employer would be at risk of a reverse age discrimination claim if younger workers were required to come into the office while older workers telecommute. And I just want to mention the flip side of your scenario. An employer could not, out of safety concerns for older workers, require them to telecommute if they didn't want to. They couldn't say, hey, we're really worried that you're going to get sick, so the rest of us are returning to the office and we're going to, have team meetings and a lot of work's going to be done, but you're doing fine at home, continue to telecommute. If the older worker wants to return to the office and the employer refuses to allow them to come back, that is an ADA violation. In fact, that's a facial discrimination case under the ADEA. And the relevant Supreme Court case there is a Title VII case called International Brotherhood Union UAW versus Johnson Controls, which was decided back in 1991. And in that case, the court was looking at the company's protection of women in childbearing ages and saying they could not do certain jobs that were deemed dangerous to women in that category. And the court said it doesn't matter that the employer's intention was actually good, that they were trying to protect the worker if they are denying them a term or condition of employment. I just wanted to mention that, there's kind of two sides of that coin, and the answer is different depending on the situation.
Thank you, Lori. Hi, do you have anything to add with respect to the ADA on this question?
So the ADA obviously doesn't cover age per se. Age per se is not a disability, but obviously sometimes people who are older might also have some of the underlying health conditions that the CDC has said will put them at higher risk for serious illness if they contract COVID-19. Again, very important. Sometimes people just say high risk individuals, and it's important to understand these are not folks that are higher risk of getting infected. It's just that if the person gets infected, higher risk of getting a serious illness. Of being impacted seriously by COVID-19 and potentially dying of it, as we have seen so many of our people in our country dying. And that is part of what makes employers sometimes want to say, you all stay away. So in terms of people with those health conditions that would put them at more serious risk of more serious illness, unlike ADEA, that was very clear, you cannot say to those folks, we'd like you to stay home. because the ADA has a defense for an adverse employment action if the individual poses a direct threat. Now, the EEOC in 1991, after the ADA was passed, in its regulations decided that direct threat meant direct threat to others or to self, right? So that was challenged at the Supreme Court, and the Supreme Court said EEOC was legitimate in saying that. So direct threat to others is what allows employers to keep people who are infected with COVID-19 out of the workplace. Direct threat to self is what some of the employers wanted to use to say, well, we think you'd be a direct threat to yourself if you come into the workplace. And what the EEOC has said, and again, the EEOC sends out these answers, adding them as they write them. So you always have to keep refreshing, going to that. I know I sent in the link for the EEOC. You can see what they've said so far, and then, go back to that link. So in one of their later Q&As, they said, yes, direct threat to self applies, but it is an individualized assessment. So you can't say, well, everyone with asthma is one of the conditions, or everyone with liver disease. It has to be an individualized assessment. It's a very high standard. It's significant risk of substantial harm. And it's based on a series of factors, how likely it is that the harm occurs, how significant the harm will be. And so employees would have to do this individualized assessment. I think as a practical matter, that means certainly employers are not going to have a rule that says, if you have one of those health conditions and you want to come back to work because we're reopening, they couldn't keep them out of the workplace. It does, however, mean that if folks, and it's sort of what Lori was saying for age, if you are at higher risk of serious illness, if you get COVID-19, you don't want to necessarily come back to the office. And so many companies and organizations are now realizing that, hey, work from home can be as productive, if not more, than work from office. I mean, it's work, right? And if you have good metrics in which you're determining whether people are working. So a lot of companies are doing that, and organizations, but a lot of others are still, no, we want everyone to come back. And at least here, there is a reasonable accommodation obligation on the employer to allow the person with those underlying health conditions to work from home if the job permits that.
Thank you. Let me take you high to a different question, but clearly related. So what about someone who works in a nursing home, for example, or she works or he works in retail or in another essential job which cannot telecommute? And that person is 65 or older, or may have a condition identified by the CDC at putting them at higher risk for COVID and, unfortunately, even death. That person is afraid to go to work. She or he does not want to go to work. What protections does the person have under the ADA when the employer says, no, you need to come to work. I need you to be at that store. I need you to be taking care of that employee, that person in the nursing home. What is that employee? What kind of rights does that employee have?
Well, unfortunately, not that many rights under the ADA. And I think this is why it was so important to, at the top of the program, acknowledge the impact of race in America. Really, I mean, we all sort of sometimes say it and then it just goes away, and we can't do that, right? Being Black in America today is different in ways that many of us were not taking into account in the way that we needed to have. Same as well for obviously other people of color, but I really do want to call out that there is something we need to understand in terms of being Black in America today. And of course, that has an impact in terms of the types of jobs that people have. So disproportionately, we are seeing Black people, brown people, people of color in the type of jobs that are less likely to be able to be amenable for work from home. And then here's where our laws protect and don't protect, right? So if it's not possible for that person to work from home, The one thing the ADA provides that person is a job protected leave of absence. In other words, the employer cannot simply fire that person. Under the ADA, the accommodation of last resort basically is almost last resort is you get to stay away from the office, but it doesn't have to be paid. Leave has to be job protected under the ADA. It does not have to be paid. So again, you're going to see the disparity based on income. In a lot of jobs, people have paid time off or, all different names for vacation, and a lot of employers are allowing employees to pull down on their paid time off, sick leave, even if they're not sick. But if you're in a job where they're not providing paid leave, then that's a problem. Now, Congress did take an important step in the Families First Act by creating for the first time a federal paid leave mandate. And that would cover people who, under these state and local orders are being recommended to stay at home. In the paid leave provision, a stay-at-home order is something that will trigger at least 2 weeks of paid leave. It's just 2 weeks, but it's 2 weeks of paid leave, but only if you're working for a business organization with fewer than 500 employees. Those businesses, those organizations have a mandate to provide the leave, but it's completely paid for by the federal government. And the way they set it up, it's called a tax credit, but you know what? You don't have to wait for the IRS to send you back anything. They made it so easy. You can just keep the money up front, and then you just send back to the IRS any money you didn't spend on the leave. So for those folks, that'll be helpful. But if you don't have that, ultimately, you're in the unemployment insurance system. And again, in a separate stimulus act, I'm sure you'll know, the CARES Act, the government did expand unemployment. It expanded it in terms of money. So regardless of what you would ordinarily get under your regular state benefit amount, you get an extra $600 a week until the end of July. They expanded it in terms of time. Different states have different number of weeks that their unemployment goes for. Federally, it will now go till 39 weeks. And added other reasons for getting unemployment insurance. And this would be one of the reasons. If you could not go to work because of but again, because you were actually unable to go to work because you were at more serious risk, high risk of serious illness. So again, this is not protecting everyone. This is not protecting someone who's just afraid. I'm just afraid. You don't get unemployment for that. You don't get paid leave for that. You have to depend on your employer creating a safe workplace. And we could talk about some of the aspects of that, but that's what those employees are depending on. That their employers are creating a safe workplace for them.
Lori, just to follow up on that, what about under the ADEA? Is there help under the ADEA? And what about a question of a reasonable accommodation under the ADEA?
Well, unfortunately, the answer is there is not much of any help for that individual under the ADEA. As I believe Hai has already mentioned, there is no reasonable accommodation requirement under the ADEA, and therefore employers are not required to accommodate the fact that older employees are at high risk of becoming seriously ill from COVID by allowing them to telework or to adopt any other safety precautions. And I have to say, I've been an ADEA lawyer for practically 30 years and an older worker advocate for over 30 years. And, the idea of a reasonable accommodation for age before I would very much be against, because the idea is age is not a disability. I think it goes against all the bedrock principles of the ADA, that age is irrelevant when it comes to employment. So, this is the first time in my 33-year plus career that, where you actually think that, boy, that might be a good idea to have a reasonable accommodation under the ADA. Despite kind of some of the things that make you worried about it. But the fact of the matter is, right now, it's not there. And as a result, older workers who fear returning to work and refuse to do so if their employer does not allow for any flexibility, and I do advocate employers being really flexible in these times, they do risk termination because employers are not required to keep them on indefinite leave because they're just afraid of coming back into the office. Now, with that being said, you need to watch what's going on in the greater workplace. So if I'm an older worker and I say, I'd like to continue to telecommute, it makes me really nervous to come in. And my employer says, no, I'm sorry, I need you to come into the office or come into the nursing home. But then I find out that I have a younger colleague who said, hey, I need some flexibility. I'd like to continue to work from home because my kid's childcare is closed, or which I think right now, and yeah, lack of childcare. So let's take that one out of the example. But say I don't think elder care is elder care. I don't think elder care. So I'm taking care of my older mother, and I need to telecommute for a while longer, and the employer is flexible there. So anyway, you want to watch, like, are younger people with concerns that aren't age related but require, make it better for them to telecommute, are they being accommodated? And I'm not, because of my fear of being, older and vulnerable to COVID. So that's where you might have a claim, but otherwise there is no reasonable accommodation requirement under the ADEA.
Thank you. So, Lori, let me go back to you. Many workers have been laid off due to COVID, and all the reports are that more people will be laid off as well. What's the impact on older workers, and how does the disparate impact theory apply under the ADEA? And do you see any change occurring in that concept under the ADEA under COVID? And as long as you're speaking about layoff, could you also speak about discrimination in hiring as well? Because it seems to me the two really do go together. So could you speak about that for a few minutes, please?
I mentioned right from the start, older workers are always at risk in layoffs. If you look at the EEOC charge statistics, you are always going to see high peaks when the economy is in crisis. I like to quote James Carville, it's the economy, stupid. When you see the charges skyrocket, it's usually because the economy is not doing well. So, and older workers tend to be to bear the brunt of layoffs because, as I said before, like the assumptions that they cost more and that they're not willing to adapt to change and they're not willing to learn new technology.
Oops.
That this is going to be especially true during the pandemic. Now, courts are not going to second guess an employer's reasons for laying people off, and they shouldn't. I mean, but what we need to scrutinize is the decision making as to deciding whom to lay off, which is very hard to do. I litigate cases. You're not privy to that, and you have to use your discovery tools to try to get to the bottom of that. But one thing that older worker advocates have in our toolkit is under the Older Workers Benefit Protection Act that was passed in 1990. If an employer has a layoff and they ask any people who are getting severance benefits as a result of the layoff to waive their rights and claims under the ADEA, which they often do, although now you're seeing more employers just opting for mandatory individual arbitration clauses. But if they do ask people to sign a waiver in exchange to receive severance benefits, they must provide any worker asked to sign the waiver with a list of job titles and ages of those who are being terminated and the same list of job titles and ages of those who are not being terminated. So at least as an older worker, and hopefully you're going to provide it to your attorney, you can eyeball those statistics and try to get a feeling, does it look like older workers are being targeted in this layoff? And that way you make a more informed and voluntary decision whether or not to sign the waiver and take the severance benefit, or if you want to challenge the layoff as targeting older workers. Now, I will say in practical terms, and especially during these times, and you're more likely to take the severance because you need to buy groceries and you need to pay college tuition. But those protections are there, and they're very, very important. You mentioned the disparate impact theory. Disparate impact is when the employer policy or practice is facially neutral, so there's no mention of age, but the practice has a greater adverse impact on the protected class, so in this case, age. One of the biggest ways that the ADEA differs from Title VII is the standard for disparate impact, the burden the employer must meet to successfully defend against a disparate impact case. Under Title VII, that standard is high. It's business necessity. But under the ADEA, it's a really low standard. It's reasonable. It's comparable to the rational basis review in a constitutional challenge. I think it's like anything goes. Almost everything is going to pass muster under a rational basis review. And I think any disparate impact challenges to layoffs that seem to disparately impact older workers are going to be especially hard to bring and to win in a COVID atmosphere, because I think the courts and the public are going to be especially sympathetic to employers who are facing these incredibly hard economic times and are being told that older workers are vulnerable to getting sick and are going to have costly insurance claims. So I just think it's going to be an especially difficult environment to challenge these reductions in force, and yet I do think older workers are going to be bearing the brunt of them. Now, to continue my negative diatribe, you asked me to talk about hiring. As we saw in the Great Recession of 2008, when older workers lose their job in a reduction in force and are unemployed, they face much longer periods of unemployment than younger workers. In fact, it takes them usually twice as long to find another job as a younger worker, and often when they find another job, it's going to be for far less money than they were making before. I think, again, the pandemic is going to throw jet fuel on that statistic because of all the reasons we've been talking about. Employers are going to be reluctant to getting sick and vulnerable to getting really sick. And they are, nervous about that. They're very nervous about it. So already it was it's very hard to prove age discrimination in hiring because you're more often than not, you're not given the reason why you're not hired. Most hiring is done as online. So you're, throwing your resume out there and you're not getting responses and you don't know why. So you don't know whether or not it's age discrimination. You just have a hunch or a gut feeling. But I think that it's going to be even harder because if there's any indication on your resume, and it's pretty easy to find people's ages out these days, unfortunately, I think that there's going to be greater reluctance to hire an older worker.
Esther, can I just, and maybe this will be.
I was just about to turn to you. Hi.
Well, look, obviously so much of this is so hard. Hard things will be happening to everyone. And I think that so much of what we're talking about, what I'm talking about to my clients now is about the importance of workplace culture, having a sense of collective responsibility. By the way, that's the best way to have a safe workplace. There are all the, CDC has a very good checklist. The other link that I sent is what I think is one of the best CDC documents that really lay out what employers should do. Some things they have the right to do, they can control how many people in a meeting, how far the desks are from each other. But a lot of other things, like staying 6 feet away when you're having a conversation or wearing a face covering, employers can't be everywhere all the time. So it really depends on creating a sense of collective responsibility. We all need to care about the safety of our coworkers. And that will absolutely be the case if someone who is older has to come back because that person cannot telework, or the person with the underlying conditions cannot telework. So it's a choice between the salary or working. But I think we're seeing some of that collective responsibility. So that gives me some hope. The other thing I want to say in terms of reasonable accommodation, and Lori and I had some discussion about this. So as you see, the two reasonable accommodations that people over age 65 don't have, that people under the ADA do have, is if you are able to telework, you've been doing a good job, you can, the employer doesn't have to give the person over 65 the ability to do that. Well, they do have to do it for the person with a disability. Or if the person cannot telework, cannot come in, if the person with the disability decides, no, I'll forego the money, at least that person has a job protected leave and age doesn't. One of the things that's interesting is that the concept of reasonable accommodation came up first with religion, had nothing to do with disability. After the Civil Rights Act passed, the EEOC in its guidance said, well, yeah, civil rights means you treat everyone equally, right? Well, treating everyone equally doesn't mean treating everyone the same, because people aren't the same in the first place. So if you're an Orthodox Jew, as I grew up, right, you were told you had to work Friday night or Saturday, that's it. You would have to give up the job. So saying, well, we require everyone to work Friday night and Saturday is not necessarily achieving equality, because they're not the same in the first place. And then the Department of Health and Human Services that wrote the regulations under Section 504 of the Rehabilitation Act borrowed that concept for disability. Because again, it doesn't help to say, oh, everyone can come in through the front door. Yeah, if it has steps, that's a problem. The whole point is you need to give a reasonable accommodation when someone is not similarly situated to others. And I think at this point, right, I mean, people who are over 65 for this COVID-19 pandemic are not similarly situated to those who are under the age of 65. But as Lori correctly said, as EEOC repeated, at the moment, there is not a reasonable accommodation piece requirement in the ADEA. But I think if it does get read into that by the EEOC, by the court, I don't think it's saying that age is like disability, generally. I think it's saying in this moment in COVID-19, there is a reason why people over the age of 65 might get something that people who are 50 don't get.
Great. Thank you for adding that piece. I think that's an important piece of looking forward in terms of things that might be coming down the pike. So at this moment in time, I would like to remind everybody that in the chat, you will find the URL for the evaluation for the materials. And I'm now going to tell you the code that you need to put into the evaluation. It is ILR 1945. ILR 1945. And if you don't want CLEs, you don't have to indicate a code, but we do want you to fill out the evaluation. In addition, you'll see the URL for our new program coming up on the 25th, which will look at the ADA and the intersection of the ADA for people who have disabilities such as sight impaired, hearing impaired, in a wheelchair, and how buildings and building managers and employers will have to work together to meet those issues. And you will see that URL as well. Now, let me look at some of the questions that we have for all of you. This is anonymous. I am 62 years old and have a note from my doctor that says I need to work from home because I have asthma and an irregular heartbeat. Do I have any rights?
You do, but not because you're 62. You do because you have asthma. And by the way, because I think this, I mean, at the at the CDC link, I might ask to send you yet another CDC link that has the list of conditions. So I just want to say that so people know. So asthma, liver disease, kidney disease if you're getting dialysis, diabetes, immunocompromised, which can be caused by any number of conditions, but immunocompromised, serious heart conditions, severe obesity, and about a few weeks ago, CDC added hemoglobin disorders. In other words, disorders of the blood because of some issues about blood clotting. And to the extent that that list gets expanded, it will be on that CDC link. So because you have asthma, yes, you have rights. It's going to depend on what your job is, right? If it's a job in which you can telework, you have been teleworking, you get to keep teleworking and getting paid. If it's something where the employer can say, yes, you've been teleworking because we're under a stay-at-home order and we were just trying to get whatever we could get done. But now really your job, the essential functions of your job require you to be in the office. No, even though you have asthma, you're making the choice. Do I want to go in the office and get paid? Do I want to stay at home and have a job protected leave, but potentially unpaid?
Lori, we have a question for you. Based on the example you gave, how should an employer document where the Family Medical Leave Act and the ADEA intersect and the ADEA and it conflict?
I'm not sure.
No, I don't think FMLA, FMLA will allow you to take job protected, unpaid leave off to care for someone, a family member who is ill, right? So if you have a family member that's ill and you're taking off to care for that person, the employer can't fire you. Under the paid sick leave law, so again, for folks working for an employer with 500 or fewer employees, if you need to care for someone who has COVID-19 or has to self-quarantine because they've been exposed to COVID-19, you get 10 days of paid leave, paid for by the government. Initially, they also had an additional 10 weeks under FMLA. So the law says you have 12 weeks of FMLA and they restricted it only if you had child care issues because the school was closed. Now the camp might be closed. You don't have daycare. And the first 2 weeks of that could be unpaid because you were getting it paid through the first 10 days. And then the following 10 weeks, it's the only paid requirement under FMLA. It only goes till the end of December 2020. But that's paid for, but only for childcare needs. In the additional stimulus bills that have been dropped by the House Democrats, they have lifted the cap of 500 employees. They have extended it to being allowed to care for an elderly person. Not a care for a family member. I will say in terms of intersection between FMLA and the new paid leave, for those 10 weeks, the employer can require that paid leave to run concurrently with any other paid leave that's available. And those 10 weeks will count against your overall 12 weeks of FMLA that you have over the course of the year. So if you use those up, you're not going to have it for other FMLA purposes.
Thank you. Another question. Does the employer have to take the employee's commute into the office into consideration, meaning that the employer can accommodate the member not wearing a mask in the office, but because the employee's commute involves public transportation, the employee would be required to wear the mask during their commute? So especially in places like New York City or DC where there'll be a subway commute.
Right. Well, we're certainly recommending in terms of safety precautions generally that you consider whether you have alternatives for your employees. Can you give them stipends for parking, etc. But that's just voluntary, except if you have a person with a disability who cannot wear a mask, and the only time they would need to wear that mask would be during commuting, then yes, it would be a question of whether giving that person a parking spot or paying for that person's parking would be an undue hardship. I mean, with large enough companies, that should not be an undue hardship. I will tell you that I had someone who decided he was thinking about buying scooters. He didn't have a lot of employees, but he thought he would buy scooters for some of his employees. He wanted them to come in. He didn't want them to have to take public transportation. But not everyone's going to do that, but that is a place where there is a reasonable accommodation for people with disabilities. If there was reasonable accommodation under ADEA, that would then apply. It doesn't apply now.
Okay, next question. I think we touched on this, but I think it bears more discussion. If a person has someone in their home who is at high risk, and the person has been teleworking for the past 3 months, and the employer now wants everyone to return to work as part of the reopening process, is there any protection for the person under either law? Any way to spin it as an association claim? That would be under the ADA.
Yeah, so no, that person doesn't have that same reasonable accommodation right to say, I want to continue to telework because I want to make sure that I'm being as safe as possible, given that they are at high risk. There's no accommodation requirement. Under association, you can't discriminate against someone because they are living with a person with a disability or associated with a person with a disability. So you can say, I'm going to fire all the people living with people at higher risk because I don't want them to, infect that person. But you don't have to provide an accommodation to them. Again, I will tell you, at least in terms of the clients that I am counseling, to the extent that they can accommodate their employees' needs, they are trying to do so. At least the ones I've been talking to. And a document we put together, a guide and a policy, we call it reasonable accommodations and alternative workplace arrangements. Because we want to say reasonable accommodations for those you are legally obligated to provide, but then alternative work arrangements that you could give. And these are the examples: people who are over 65, people who are living with someone who's at high risk, people who have elder care responsibilities or child care responsibilities, none of which have the right to those alternative workplace arrangements, but if you can give them, why not? As a matter of morale, and I certainly have seen, and again, I'm at Morgan Lewis, we counsel a lot of large companies, but I have been really struck by at least the effort people want to put in to see what they can do.
One last question. Can the employer require you to transfer locations to keep your job rather than allow you to stay home and telework if you have a disability?
Wow. I always love doing these because there's always a question I haven't heard. So thank you, whoever sent that in. But here's my question. Why would transferring locations, do you think, I know we can't necessarily hear back from the person who asked, but the employer says, okay, if you transfer to another location, then somehow there won't be the same risk? Maybe you should read the question.
They haven't answered, but I'll suggest maybe they don't have to take public transportation.
Oh.
So that they may be able to walk to work as opposed to having to get on the New York City subway, for example, or the DC subway.
Yes, the employer can certainly ask that. We always know the whole point about an accommodation is it's an interactive process. You suggest an accommodation, the employer might give you that, or the employer might come back and say, no, here's another accommodation. And it's not the employee's preference that will control. Although, of course, I'm sure anyone who gets to walk to work instead of taking the subway will be more than happy.
Mm-hmm.
We have just a minute or two left. And so this may be a longer one. Let's see if we can do this one quickly because it's so interesting. The National Basketball Association is currently discussing their return to work plans, and the potential is for coaches over 65 to be banned from coaching. Do you believe these teams would have to engage in direct harm analysis? And what would be the steps for an individualized analysis? And we only have a few minutes, but I thought it was such a great question.
It's a great question, and it's a real question. I mean, that's really happening.
Yes.
And no, I mean, there is no direct threat defense, as Hai already pointed out. So, so if a NBA team refuses to allow Greg Popovich or some other older coach from sitting on the bench, that is a violation, a facial violation of the ADEA. My boss actually asked, well, what if like they allow them to sit up?
You keep.
I mean, they could do that, and and if they're still paid their full salary, then there's not much monetary damages under the ADEA, but still, they're not allowed to do it. If the older coach wants to sit on that bench, they are entitled to sit on the bench. So that's an easy answer to a very interesting question.
Well, thank you. I want to thank Kai and Lori for a fascinating discussion. Thank you both very much for agreeing to participate in this Zoom. I want to remind our participants to please go to the chat. There's a URL there for you to fill out your evaluation. I did give you your CLE number. You will also find all the URL for the information which is on our website, and any information you'd like to know about our next program, which is on the 25th of this month. Again, thank you all very much for participating, and I hope to see many of you virtually on the 25th. Thank you so much.
Thank you. Bye.
Thank you.
Bye.